Bam, and we are live. Welcome to the show tonight, everybody. Pro Se Legal School. I like the way that sounds. Those of you coming from Facebook, please follow this link over to StreamYard and give StreamYard permission to use your Facebook username. That way, if you have something to say, we'll know who you are if you want us to. So that's how that's going to work. I'm going to leave that rolling up there for a couple of minutes. And we got some people here. Frank-a-boo-boo. Frank-a-boo-boo-do-do-do. Welcome to the show tonight. Frankie and John, you guys are the first ones up in front of the ring. I like that. Time's up. We got some stuff to talk about tonight. So we are going to get rolling here. And as soon as we get everything lined up, we got a few new people in the program this week. Prosecutor Eliminator package is hot. And if there's anybody on the stream tonight that invested in that package, and had a chance to review the documents in that package or the strategy there within, pipe up and let us know what you think. Let everybody else know, because I already know, but they might need to know. Prosecutor Eliminator package is fire. And this package people are using to address the criminal prosecution situation without an injured party or damaged property. Without an injured property or damaged property, party. Y'all know what I'm talking about. Without those two things, the court don't have jurisdiction to do squat. And the judge signed on without those two things to either give your shit away or send your ass to the pokey without, injured party or damage to property. And therefore, what they done, and this is just my opinion, and remember, I don't know shit because I play football and I box in college. Those are two things not smart people do. So I tell attorneys. So I don't know. But what I do know is that codes and statutes and codes, criminal codes, none of that shit are valid laws. They're not valid laws. They don't have enacting clauses. They don't have titles. They don't have bodies. So if you're facing foreclosure, they're using a foreclosure statute to come after you. A foreclosure statute that they made. What's the statute? Statute is a policy from a corporation. Yep. So they made a policy to come after your ass, and then they paid the judge to enforce their policy. Sounds kind of shady, don't it? But that's okay. So to them, it's not shady. Okay, it's not shady to them. Because what they do, what they have done doing is moving your happy ass over to their administrative court where you have no rights at all. Because, well, none of their courts are from the Constitution. I don't give a shit what you tell me. But for the sake of this for this point, so they move your happy ass over to their administrative court, where they can do whatever they want to you, and they make the rules up as they go. Somebody tell me I'm wrong. I work with a lot of people, and I've been through a lot myself. So when it comes down to this criminal stuff, I didn't have to do a lot of research for that because I lived through that. And no, I'm not being convicted of anything. And anybody that tells you that need to back that shit up with, no, I ain't never took no deal either. And they wanted me to take the deal, throw my sweetie under the bus, throw my wife of 42 years under the bus to get out. No, I told them, I told them I was not in a hurry to leave because I like the food in the jail. Yeah. Yeah, that really pissed them off. So let's get rolling with what we got to talk about today. So welcome to Approach to Legal School. I provide the tools you need to work. Yeah. Y'all know all that. So tonight we're going to do just a little update thing on stating a claim for relief, on how to state a claim for relief. We're going to also kind of touch on a few of the tips that we touched on last week for when they start stalling your lawsuit, or these tips can be used to turn up the heat on their ass just because you can. So we're going to talk about those two things. But before we get started on all that, y'all, please click on those ads. Click on those ads so I can get you to ching chang. Yo, click on those ads so I can get paid. Make sure you subscribe and ring the bell, and please hit the share button. Hit that share button. And this is what's hot. Oh, I forgot to click the button. I got to send it first. There it is. There it is 5 times. I went to all of the sites we're streaming to. Yeah, that's a prosecutor eliminated package. It's still on sale, marked down just a bit because the gate is open. Remember, when the gate's open, some's on sale. So when y'all see the gate open, some's on sale. Now, for you new people who don't understand what the hell I'm talking about the gate, you'll see a few posts and a lot of the shorts that I do in front of this gate. There's this badass gate on the way on my 3-mile walking and jogging path, trail, road, and we make a few videos at that gate because that gate's. You guys have to get your butt to the gate. And you do that by going to my website, like when you get done watching the YouTube video. Okay, don't call me. Okay, don't email me. Take your butt to this is how you get to the gate. You got to go to my website at winningcourtnow.com and take a look at the legal options that you have. Study the description of all of the lawsuit packages. And you can also take a look at the documents that you get in there. Now, keep in mind the documents have changed because of the updated real-time feedback that we get from the people in the private coaching group. So you are your own attorney. Okay, you need to look at that stuff and you need to decide which package you need, and then go and look at the updated instructional videos. All of them. There are maybe 4 or 5. No, I'm not talking about 500 videos. I'm talking about the updated instructional videos that are in the instructional video playlist. The updated instructional videos outline how steps that you need to take, that we've implemented on using the 42 USC 1983 Civil Rights Lawsuit Package. Now, I had a person watch one updated video and thought they needed to move their case from state court to federal court. And we don't do that anymore. We did in the first updated instructional video, and then we made 3 more based off the real-time feedback, and we don't do that anymore because they started stalling. Yeah, if you leave it in state court, we don't file. If you leave it in the eviction court, or just file in state court and don't do the steps that we have outlined, then state court's going to be on the phone with them, telling them to stall your ass because they're going to move you up on the list on the eviction protocol and see if they can get the people out and to throw your shit in the yard sooner. So that's how that works. You have to. The updates were made based off of real time feedback from people like you guys that are using my shit. So I'm thinking if there's 100 updated videos, I'm gonna watch them all. Those videos are way more important than the other videos that's in it. The other videos are the videos that we use. They're training videos. We what we have in those videos is what we learn to get to where we are. Now, where are we? Guys, keep up. Come on now, keep up with me. Right now, we don't go after them for the lies that they said in court. The lawsuit package it's not non-judicial foreclosure or it's not judicial foreclosure. We threw that shit in the trash. We threw that in the trash. And the reason that we don't use those anymore is because of the real-time feedback that come in. So this program was built off of real-time feedback. We threw that in the trash. So now what we figured out that we have to do is we have to sue their ass for the reason they got you in their administrative court. The reason you're in their administrative court. The reason you're in their administrative court is because of the state's day-to-day procedures and processes that violate your due process. Yep, they violate your due. What the hell is your due process? That means shit's supposed to be fair. I almost said free. Actually, it's supposed to be free too, because your signature is supposed to pay all your debts. Okay, but that's a whole bunch of other videos. So, yep. So we're gonna get started. The prosecutor eliminated package is hot, and I've got some good feedback and good reviews on it. I haven't had a chance to post them yet, but I will. And this package is hot too. Now I'm going to be making a few changes to this, and there's just going to be cosmetic changes. So slow down, you guys who have this already. Now, the online course was on Teachable, and the lawsuit package in the online course is totally different than the lawsuit package in the $600 course. Now, sure, in the online course, we also addressed the 42 USC 9, the due process violation. But what we address first in online course lawsuit is the mortgage fraud. The mortgage fraud. The online course lawsuit addresses the path the mortgage fraud took. Like, for instance, one of the things that you're demanding in that lawsuit package is that you're demanding. So you're saying there's 6 things missing from the contract they filed in court against you. And one of those 6 things that you're saying is missing is that agreement that you had with the lender. You and the lender agreed to do the deal according to the GAAP accounting principles. Uh-huh. And so the lender, the alleged lender, or excuse me, I don't want people to get the wrong idea and think that I don't know what the hell I'm talking about. So the alleged lender / debt collector attorney, okay, they can't. The lender is not about to say they did anything, and they're not going to want nothing to do, and they don't have anything to do with the foreclosure after it gets into the foreclosure process because they've already written it off their taxes, claimed it on insurance, got the money from you through their scheme to make you pay for millions of years, and took the house back and gave it to the third-party debt collectors, or somehow they got it. I'm not exactly sure how they got it, but I know they got it. They got it. They got it. And the other thing is, in non-judicial foreclosure, people, they tell you, oh, we don't have a file. There's no file. That's total bullshit. They do have a file. If they didn't have a file on your property, okay, if they did not have a file on your property, there's no way in hell they could sell your property on the courthouse steps in 30 days. Okay, those people down there organized for shit, except when it comes to taking our stuff. Okay, that's when it comes to taking our stuff. Your didn't say, yeah, it's on fire. Yeah, like I said, this package is. I structured this package. with the hater in me. Yeah, that's a good way. That's a good way to put it. So the online course, the new online course that I'm structuring on my own website, so it can't get whacked, is going to have a new lawsuit in it. Now, the lawsuit in the new online course is going to be for real estate deed fraud. That's it. It's not going to be for foreclosure. It's not going to be for none of that shit they want to talk. It's just going to be for real estate deed fraud. It's not even going to be for civil rights violation because that stuff just waters it down. The real estate deed fraud. Yeah. The real estate deed fraud occurred when they registered your deed in their office instead of delivering it to you. The state law said that shit's supposed to be delivered to you, but that's not what they did. They registered in their office, and this is my opinion, okay? That registration allowed the first illegal lien to be put against the property. Uh-huh. And the first illegal lien was the mortgage lien. And the reason it was illegal, think about this. If there were several people who owned property before they could take out, all the owners have to be present to sign. So the way I see it, I'm just a simple-minded ex-person that beat myself up. Yeah, so the way I see it, it's real estate deed fraud. Real estate deed fraud. So that's just keeping it simple and all the other stuff out. If they don't deliver your deed, they didn't. They registered in their office, and then that allowed the first illegal lien to be put on your property. So the question here is this, and I don't know. I have to ask a question, or they start trying to yank my stuff or say I'm lying and scamming people and stuff. So, but the question is this: if your deed was not in their office, would they be able to verify that there was a lien against your property? Ah, well, that's the question. So I don't know. I don't tell people what to do. Now I do coach you in my program, but I don't. Yeah. So I'm thinking, and then one goal would be to get your deed out of their office. Yeah. So once your deed's registered in their office, okay, then they reclassify your property as commercial, residential, agricultural, for the sole purpose of illegal taxation. Right. Because the Constitution says they can't tax your private property. So they have to get your property on paper as not private property anymore. Uh-huh. And then once they start the property taxing crap, that opens the door for the code enforcement and those people up in your face about, well. So that's going to be this online course now is going to be the foreclosure lawsuit, the fraud, mortgage fraud. It's going to be a mortgage fraud lawsuit. I'm not even going to worry about calling it foreclosure. It's going to be a mortgage fraud lawsuit. And we're taking the foreclosure out of it because here's the thing. You don't have to wait till you're in foreclosure. You don't have to wait. You can challenge your damn mortgage bullshit at any time. You don't have to wait till you're in foreclosure. And that's the reason why we're doing this. Now, the new online course that I'm putting together with the real estate deed fraud and the stuff in it that's going to be like badass is also going to contain the property tax package. It's also going to contain the traffic package. It's going to contain everything. This new course that I'm putting together is going to be a business. It's going, if you invest in this course, it will allow you to set up and run and do the same thing I'm doing right now. Okay. Now, there's a whole lot more to it. You got to get YouTube. You got to set up. You got to do. But at some point along the way, all those things are going to be lined out that you have to do. And those things aren't very hard to figure out once you get rolling. And that's what this new course is going to be structured as the total package. One of the other things I want to touch on before we get started here, I'm having a little trouble with the files going out at checkout. So some of the files are going out. I think what's going on is that the zip file is not staying zipped when it goes into my website. So I've got an appointment on Tuesday to meet with the people that take care of my website, and we're going to get that figured out. In the meantime, if you make an investment and you don't find the zip file or the files in your spam or in your email address that's connected to your payment method, give me a call, or actually give me a call. That way I can make sure I don't want you texting me or whatever, because I might not see it, or I get 100. Give me a call and let me know who you are, and I already probably know who you are because I see the email when those sales go through, and I take a personal interest in each and every one of them. And if you invested in a package, you probably got an email from my website. And then you actually probably got an email from me too. And you can tell the email that came from me. It might have some grammar errors. Okay. I do have a program to help out with that, but I'm just saying, you can tell. Now, one other thing I want to talk about before we get started, and this is like very, very important. What we're talking about today, how to state a claim for relief, whatever, we're talking about that because, well, if you invested in my stuff lately in the last, I don't know, 7, 6, 8, 9 months or whatever, I don't know, some period of time, all of my documents are structured to state a claim. Now, if you're doing this on your own or whatever, and you need to amend your thing, well, we don't amend nothing here. What we do is a supplemental pleading. We never amend anything. Do a supplemental pleading. How do you learn how to do that? Well, you go to the Federal Rules of Civil Procedure and you look up amendment, the rules for amending your document, your claim, or whatever. Okay. And then you scroll all the way down to the bottom, way down here at the very bottom, almost where the little tiny ass number is. And then you'll see it says supplemental pleading. And so that's what you need to learn to do a supplemental pleading. And it's pretty badass. Okay, that's what I did in my sister's case, but I can't talk about my sister's case. So she's my friend too. So I did that in my friend's case. Supplemental pleading. So when you do a supplemental pleading, you have to add a party or add a count or both, and they have to be connected to the original reason why you're in the court in the first place. So that's pretty damn easy. Who's that, the clerk or the eviction? I mean, somebody standing in the hallway that works for the city. And there's no number of supplemental pleadings that you can do. And it's kind of cool because when you file for an amendment, they provide you with an opportunity to do one amendment without asking the court for permission, which is totally BS in my opinion. But we don't have to worry about that because we don't go down that route. There's no saying on the supplemental plea you can and they was not happy about it. They already had their document to object to my amendment, and then I came in with the supplemental plea and bam, blew their ass out the water. And the judge recused himself. So you want to do a supplemental plea and then get your stuff filed in court. So I wanted to do that before we get started, because if you have to make changes, you need to know how to make them, or you're still going to be shooting yourself in the foot. So stating a claim for relief. Let's get rolling. So in pro se cases, attorneys often use this motion to dismiss failure to state a claim for relief under 12B6. And it's pretty much their go-to thing, even if you stated a claim for relief, because they're going to go for broke and down with the ship, so to speak, because they don't have no other option. Especially when it comes to stuff that I put together. So yeah. And so, but they're going to play this card to see if you know what the hell you're talking about. And then while they're playing this card that, then they're going to be trying to get your mind off of this shit and back on the payments. Okay, they need you to talk about the payments. They need to raise your blood pressure about the payments and the fear of eviction and all that shit because they use that fear and that bullshit to control your ass. Well, some people's asses. Because if you're here, they're not controlling you. But you guys know what I mean. So in general, all those defenses are put into the defendant's answers, but it's also the court also gives the defendants opportunity to raise defenses by motion before they have to file an answer to whatever it is that they're getting sued for. And this is exactly how we get out of answering to their crap. If they file, then we trump their ass with our federal 42 USC that we file in state court. Oh, they get so pissed off about it. But hey, there's no difference between doing that than filing Supreme Court shit in either of the lower courts. Okay. But here's the problem they have. You can file federal stuff in state court. I teach people how to do it all day long, but you can't go the other way. So those fools can't respond to oh, uh-huh. You create a little problem. This is how we do it. We just punch their ass a little slow at a time, let them figure it out. So that's the first thing. You file your stuff right in their case. And that jams them up because you don't have to answer as long as you got stuff on the table that's trumping everything that they brought. And you don't have to answer as long as you're kicking their ass with your stuff. Yeah. So and this is part of being in the non-conventional program. Now, what people need to be doing is going to Google and doing some research on this. I mean, I put together videos and stuff that you can watch, but I don't know, I might be crazy. The government said I was. Yeah, they got off of that pretty quick though. So anyway, so now the defendants can, instead of answering you right away, raise one or more of these Rule 12B defense motions, and it's only if the defense lose that motion that they have to answer. So it's a game that they play to drag it out and try to figure out some other kind of way to squash you, well, in the process, because they're not gonna they squash you with their process, with their procedures in court, not what you're bringing to the table, because all the stuff they got are lies. So that's just how that goes. Now, if the defendants win in their craft, then your case will be dismissed. And according to Google, they say that you have to appeal if you want your case to be reinstated. And so then I put an or after that, or sue the judge. So that's what their rules say. But we don't like to back ourselves in the corner and limit ourselves with their crap. So, and that's what I tell people when you get in my program, you can't connect my stuff to what you were already doing, number one. And you gotta forget all the bullshit that you thought you knew already, because it was just all bullshit. It's not gonna help you. So to defend a motion for failure to state a claim barring relief can be granted, you first need to understand what a claim is under the Federal Rules of Civil Procedure. So there are three parts. Well, we'll go with not three parts. There are several parts to stating a claim for relief. It's defined in Rule 8 as having three elements: a short and plain statement of the grounds that provide jurisdiction to the court, a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for judgment for the relief the pleader seeks. Now, that's what Google says. This is what Google says because the attorneys put this shit on Google for you. So, Yeah, that creates a little bit of a problem. So when you're searching for something, the first few pages of stuff you pull up is probably going to be the stuff that they put on there for you. So what they don't have on here for you is the fact that you have to itemize all of the things in your lawsuit, the stuff that you're saying is a problem. Each sentence has to be numbered. Each individual sentence has to be numbered. And and then you have to connect those numbers of the counts. Each count has to be numbered. And I number the sentences too. Each count has to be connected to a party. Now, if you don't, and it's really stupid, because if you don't do that, they try to act like they don't know what the hell you're talking about. We don't know. We don't know. You assholes know. But so that's how that goes. This is the part that they don't tell you when you study. They don't tell you when you study that you have to make sure that you connect all of the counts to the individual parties. Now, that sounds like that could be complicated. No, not really. Not for me, because I don't really like to follow their shit. So what I do is I just make sure that I have one count of conspiracy in there. So all of the defendants are connected to counts 1 through 197. Yeah, just make it easy for yourself. It don't have to be complicated, because I can tell you right now, they ain't gonna argue. They just want to pick at it to try to get the shit thrown out of their face, so they don't have to have the judge tell them to get their ass to the settlement table. That's how that goes. So my program is structured to get your stuff stopped in state court, get your lawsuit filed in federal court, and get their happy asses to come to the table in federal court and sit down without having a hearing. Yeah, this is why they said I'm crazy. But if you stop and think about it, when you add the state and you add the prosecutor, or you add the judge, and you add you add the state, the judge, and the prosecutor. When you add all of those people, so what happens to the state lawsuit? The judge can't represent himself. Judge can't litigate a case that he's parties to, and his friends can't represent him because they're so the judge is going to have to recuse himself. I don't know how else that could. So here's the thing. So when you get to federal court, you file your stuff, whatever, you get all the parties served, everything's all done. Then what I would do is I would order the federal court judge to force them fools to the settlement table, because they couldn't respond to your beatdown in state court. They have no standing to say shit in federal court. So that's where I'm at. And if the judge don't agree with you, then I would, because anytime that the judge don't agree with you, then you need to address that. And I'm not talking about filing no appeal. So no, we don't have time for that. It's a waste of your freaking time. So basically, what this means is that the complaint must contain statements that support the federal court jurisdiction. For example, the case is brought to enforce constitutional rights under 42 U.S.C. 1983, whatever. And the statement must contain allegations of fact that support each claim that's been made and a request for relief. Do I have a sample? Yes, I do. CC Pounder is on my website, and it's not a sample, it's the lawsuit. I don't do samples here. Now I teach you what you need, and I put the video stuff in my videos. You can go and get it done, but there's no samples. If you need a sample, you need to go buy the product and watch the instructional videos and do it like that. That's how this rolls. I don't have a sample lawsuit. So that's not how it goes. So it takes a long time to put this stuff together. So the stuff I'm sharing with you mainly right now are for the people who have been doing this, and there's a lot of legal coaches that are in my program too. So CC Pounder, when you get over to the website, you can take a look at the lawsuit packages, study the description. You can go to the YouTube channel and take a look at the instructional video where I outline all of the steps that you need and all of the things that you need to do. I don't discuss this here, otherwise no one cares about this because the people here, they want to know how to state a claim. So I'm just saying, this is stuff that you can friend me on Facebook, and these kind of things you can ask me in Messenger, or you can ask me on my website Facebook page, which I'll leave a link to. Yeah. Okay, there you go. We don't have a fast track here, so people call me all the time or email me and send me stuff. I'm in a hurry. I don't care. People send me an email. It's an emergency. I'm thinking they don't know me very well because I'm not even in a hurry to open that shit. I'm sorry. I'm not in a hurry to open. I don't care about what you have to stop. I don't care about, okay. If you're in this program, you're in this program to learn how to take control of this situation. And people need to understand that you can't stop the eviction process. I had a person email me today, I need to stop the sale. No, what you need to do is you need to figure out a plan to block them from evicting your ass, number one. And in that plan, you need to have a program set up to address the reason why they got this, they're doing the sale. Okay. That's what you need to address. Because if you don't address why they're doing it, you throw your own shit in the yard. I'm just saying. And this is what we learn. And this is why I don't have to hear all of the shit that people want to tell me. I don't have to hear all of that. If you're in foreclosure, did you have a mortgage lien? Yes. Okay. You're getting screwed. That simple. Oh, but it's a second. I don't care. Anyway, that's what y'all have to figure out. Okay. I don't know. Did you have more? Yep. Then you're getting screwed. Okay. Did the prosecutor come out to you without an injured party or damaged property? Yep. Then you're getting screwed. Did the judge for them give your property away? The same judge that's getting paid by the state who committed real estate default to get your property. Yep. Then you're getting screwed. So all of this stuff people want to tell me is we don't use any of it. We don't spend a whole lot of time talking about that. We spend time talking about the state's day-to-day process and procedures that are unfair and line you up to where you are right now. So that's how that goes. Now, the other thing is statements must contain allegations of fact that support claims being made by each request for relief. And they don't mention in the Federal Civil Procedure that if you fail to connect the counts to the parties, they'll move to dismiss your shit. And they'll move to dismiss it, and they'll say you failed to state a claim and try and make it look like that you didn't do none of the stuff up here that we talked about. When this one little thing here is the reason why they're throwing your shit out the window. So for me to avoid the pitfall, I just add one count of conspiracy, connect that to everybody. Conspiracy is what they use to stick up in our face all the time. And you don't even have to know that there's shit going down to be stuck in the conspiracy, which is totally ridiculous, but they use it, so we using it on their ass. Oh, that's how that goes. And so this is what they tell you. They tell you the policy behind these rules is to simplify the pleadings and not to put up technical barriers to relief. Oh yeah. I think that's a bunch of bullshit. I'm just saying. Bullshit. Because here's the thing. If that was the case, then they would put that last thing in there too, so people can see it. Hmm. I know y'all thinking, how did I find that? Believe me, was not easy. It was not easy. Now, a very important part of Rule 8 for the purpose of Rule 12B motion is the second part, a short and plain statement of the claim. This means short and plain statement of the facts that make up the claim. Now, if you're doing your own stuff, this should like narrow you right into where you need to be. So if you have any additional questions over what I'm putting here, then you need to get on the Google and use the facts that we're putting here to give you a place mark to get started. Now, one of the things you have to put in is a statement that shows what happened to you, and that you were seriously injured, and you also have to, and this is part of the bullshit, you also have to include a mental statement element required by the court. That's required by the court, and that so the mental statement element is like states the defendant's mindset. And so usually you have to add the acted with deliberate indifference to the Constitution and federal law, or both, or whatever. And without that statement, then you haven't stated a claim. So all of the things that we're talking about now are the things that if you fail to state in deliberate indifference, then your claim will be dismissed for failure to state a claim. So you must make sure that you add your specific allegations of fact to who did what, when, and who did what, where, and when, and avoid conclusions. You want to make sure you include how you were injured, by what, and what the defendant did. After putting in factual allegations, you can say something like, these facts show the defendant violated the plaintiff's constitutional rights, um, and committed real estate deed fraud, blah blah blah. And you also have to include your complaint jurisdictional allegations, like we talked about at the top of the page, and your allegations of a deliberate indifference and or other necessary mental states that you have, and request for money and relief. You have to have all of that in your claim. So the standard for Rule 12b6 motion, of course, do not favor them. And I'm saying this. I'm saying their stuff here, because of course do favor them when they can kick your ass bringing my stuff, or your stuff, our stuff, to the table. So because whatever they can do to get that off of the court record, they're going to do, and that's how that rolls. So they're going to say that you don't have a reasonable chance of obtaining relief, and dismiss your stuff. Um, what I would probably do if I had, if I deliver, if I do serve my stuff, and I knew that it was structured to state a claim for relief, and they was pulling this crap, and the judge was helping them. Okay, I don't need to go on with this, right? Well, then obviously I would object, demand reconsideration, and in my objection outline the state of claim issue and these things that I mentioned now that they're all in your, and then I would file a notice of claim against the judge, the federal judge, or whatever. It doesn't matter. Now, a notice of claim just puts them on notice that you're going to file the lawsuit. It depends on your situation. If you're about to get pushed off the cliff or something, and this is critical to keeping your ass in the ring, then I wouldn't waste my time with notice of claim. I would just add the judge to, remember, supplemental pleading. That supplemental pleading thing is going to come in really handy. Well, thank you, Cece. I sound like a troller. I don't know what a troller is, Frankie. What's a troller? Y'all didn't know what a troller is. Yeah, they are like some holes and everybody has one, but you know what? At the end of the day, if oh, so Cece, you talking to Frankie Boo? Hmm. Well, I just want to let you guys know that anybody that starts acting stupid while doing my stream and giving each other a hard time, neither one of you will be here next week. So I don't deal with drama. I don't deal with people's fear, and I don't hold people's hands. So those are a few I don'ts that I do. So let's just get this puppy wrapped up. Well, I had some things about the Supreme Court, but I ain't gonna waste my time with that because uh, now if your complaint should not be dismissed with failure to state a claim. Uh, your plaintiff, unless it is beyond a reasonable doubt that the plaintiff can't prove any set of facts, and they have a case law that they put on here. But we don't really worry about all of that because we don't usually take our stuff to the end of the road. We already know that the judge is not going to help you. So and if you don't know that, then you didn't watch the instructional video. Because I already tell you, I already told you that the judge is not going to help you get anything done. So if you're facing this situation for a failure to state a claim, then I would definitely handle it and make sure that you close the back door and hold the judge accountable. That's trying to run the show because we are the showrunners, not them. Now, the other thing we're going to talk about is possible options when they're stalling your case. And I'm really not going to call them possible options. I'm going to call it. I'm going to call them ways to turn up the heat. And Dean is in the program, and I think he had traffic package, and he had a couple other packages, and he actually got the prosecutor to drop all the charges against him, and the judge ordered his truck to be released and his boat, and they didn't release his stuff anyway. So Dean, we talked, and so Dean goes fishing a lot. So Dean's going to put he's going to put a less pendants lien against the lake where he goes fishing. Oh, yeah. So there's a lot of options. Now I wouldn't wait if it was me and they was trying to steal your house or send you to jail or whatever, especially stealing your house. I got some great ideas for stealing your house. Okay. So I would file a less pendants lien against the county recorder's office and make sure that I include the assets. Hmm. And then if they start acting stupid or whatever, or didn't answer in 21 days or whatever, it'd be like you're going to foreclose on them. Uh-huh. And then you can think about that. Then if you had control over the assets, you could give everybody back their deed to their property. Oh, I think I dream about this stuff at night sometime while I'm sleeping or something because I come up with some pretty good stuff. No, CC is really not foreign. What's foreign to you is what they're doing to you already. I had a lady telling me one day that she's that being in my program is like being in the blind, being blind. And I told her, no, I don't agree with that shit at all. I don't agree with that at all because see, here's the thing: in their program, in their conventional program, you don't even know you don't know who's trying to take your property. You don't know who's taking your property, and and they're all teaming up, paying the judge to throw. So in my program, at least you know who's coming after your ass. You know who you need to be punching in the face, and it's not the lender. And if you're in a criminal situation, it's easy. Yeah, well, we don't spend a whole lot of time in the courts, CC. When you get in my program, you'll figure that out. There's Dean. Oh, damn. Look at you go. So the judge got Dean was telling me the prosecutor told the people at the impound yard not to release Dean's property until whatever. And Dean had been charging them like $1,000,000 a day and some other shit. Yeah. Oh, that's pretty badass. I love it, man. So now the judge got down there for obstruction, and you got a show cause hearing tomorrow. Interesting. I love it. So I have a link here. I'm going to post for you guys. So that you can go to my website and take a look at the Facebook page that we have connected to our to my website. Now, this page you guys can post stuff on, and I won't be hollering at you or whatever, like I did when I had the coaching page. Um, I couldn't keep up with everything when people are posting stuff in the coaching page, and I didn't realize that this was part of what it is. So I'm kind of green on this computer stuff, but we learning. So here is the link to the Facebook page where you guys can talk to me anytime. You don't have to have permission to join. This page is an open page, and you can Dean, you can post updates about what's going on in your case here. And the video that you posted before, I'd love to have it on here. If you don't mind posting it on here, that'd be great. And let everybody see what you're doing. Yeah, that's pretty badass. I'm just gonna leave that up there for a minute. And so we're talking about right before Dean came in, people feeling like it's foreign or they're blind or whatever. So, the thing is, we are all that way until we educate our asses. Until your ass gets educated, you are blind until you get educated. Now, sad thing is, some of us, it takes us getting punched in the face before we figure it out. But we figuring it the hell out. This type of epidemic before. Oh man, you ain't even. This has been going on forever. It's just they're getting more greedy now. Yeah, that would be cool, Dean. Just take over, post whatever you want in there. I love to see it, and I think it's great. It lets other people see that people are just normal, everyday people are using this stuff to punch these people in the face. And the difference is if you spend the time educating yourself and learning what's on the paper. People get the document, they go file it, and as soon as they have a conversation with these assholes, they're talking about the payments or let them talking whatever. No, you shouldn't be talking about nothing that ain't on that paper. If you're talking to those fools about shit that they want to talk about and you're not talking about what's on the paper, you just wasted your money. Okay. I'm just saying, yeah. So that's how that needs to go. So I'm gonna be looking forward to the update tomorrow, Dean. And thank you guys for the value of sharing your time tonight. I'm going to post another link to the foreclosure offensive package that's busting some chops right now. Also, so you guys can see that stuff. And if you're facing this situation, head over to the website at wincourtnow.com and get what you need so you can post some shit on the page like Dean gonna post. Good night, Kim.